Hi, everyone. My name is Steve Blake with the Blake Law Firm in Encinitas. We are a law firm focused on real estate and litigation. We represent a lot of commercial landlord and tenants, real property owners, both commercial and residential, and lenders, title insurance companies, and other people and entities related to real estate. And today we are presenting a short webinar, and Danielle Ward is here, who is an attorney that works with me at the Blake Law Firm, and I'll let her introduce herself and talk about the presentation today.
Hello, everyone. Thanks for attending. I'm Danielle Ward, and we're going to be going over Senate Bill 1079, which went into effect January 1st. It overhauls the non-judicial foreclosure process. Feel free to jump in with any questions or comments, and we'll get started. All right, so we're going to cover the legislative goals of the bill, generally what it covers, the four main changes that are encompassed in the bill, and some general anecdotes about the potential impact, some concerns by the opponents and the proponents' hopes. Okay, so 1079 was originally nicknamed Homes for Homeowners, Not Corporations. It was introduced with the hope that foreclosed homes would end up in the hands of homeowners and affordable housing organizations as opposed to corporations, with the ultimate goal of addressing California's housing crisis. This legislation was spurred in part by the 2008 recession, where corporations capitalized on the high rate of foreclosures and purchased tens of thousands of homes, which proponents of the bill say resulted in numerous unmaintained homes and rental properties with onerous lease terms. At that time, California and Florida were the hardest hit by foreclosures. There were more than 12 counties in California that had at least 5% foreclosure rates. So between 2006 and 2012 in California, the number of owner-occupied homes plummeted by more than 320,000. And during that same time period, the number of renter-occupied single-family homes jumped by more than 720,000. This concern resurfaced recently with the COVID pandemic. According to a national survey by the Mortgage Bankers Association, more than 8% of mortgages on 1 to 4 unit residential properties were delinquent in the second quarter of 2020, and this is the highest number we've seen in the past 9 years. I did a little digging, and some research shows that we're not going to be in quite as bad a position as we were a decade ago. Homeowners have a lot more equity in their homes than they did 10 years ago, and we don't have the subprime mortgage as part of the blame. So generally, the bill covers properties containing 1 to 4 single-family dwellings. It applies to personal properties, investments, and rental properties. It does not apply to commercial properties. So the biggest change brought about by 1079 is the creation of a right of first refusal for eligible bidders and eligible tenant buyers. And these are defined terms. So an eligible tenant buyer is a natural person who at the time of the sale is occupying the property in foreclosure as their primary residence. They're occupying pursuant to a lease with a mortgagor or trustor prior to the recording of the notice of default, and is not the mortgagor or trustor or related to them by child, spouse, or parent. In addition to an eligible tenant buyer, an eligible bidder includes 6 categories: a nonprofit association or corporation, where an eligible tenant buyer or prospective owner occupant is a voting member or director; a California-based nonprofit corporation whose primary business is the development and preservation of affordable housing; a limited partnership whose primary business is the development and preservation of affordable housing; a California-based LLC in which the managing member is an eligible nonprofit corporation whose primary business is the development and preservation of affordable housing. The fifth is a community land trust, and the sixth is some public entities, including the Regents of the University of California, city district, and other public agencies. The exception to the right of first refusal exists when a prospective owner occupant is the purchaser at the trustee sale. And again, owner occupant is a defined term. It's a natural person who at the time of the sale intends to occupy the property in foreclosure as their primary residence within 60 days of the notice being recorded, or rather the trustee deed. They'll maintain that as their primary residence for a period of 1 year, is not the mortgager or trustor or related to them, and is not acting as the agent of any other person or entity in purchasing the property. So if the prospective owner occupant is the highest bidder at the trustee sale, the trustee sale proceeds through the normal course. In order to qualify under the definition of owner occupant, they need to submit a notarized affidavit, and the trustee is permitted to reasonably rely on that affidavit. In the instance where the highest bidder is not a prospective owner occupant, the right of first refusal comes into play. So within the first 15 days following the trustee sale, eligible bidders have 15 days to provide a written non-binding notice of intent to bid or bid. And they also must submit an affidavit establishing that they meet the qualifications of an eligible party. Again, the trustees are permitted to reasonably rely on these affidavits. An extra incentive to tenant buyers is that they need only to match the highest bid at the trustee sale. Other categories of eligible buyers must best the last and highest bid. Thereafter, there's 30 days for the eligible bidders to submit certified funds to the trustee. And at 5 p.m. on the 45th day following the sale, the bids are reviewed to determine the highest offer, and then funds are returned to the non-winning bidders. Another feature of 1079 is a prohibition against bundling the sale of properties to a single buyer unless the deed of trust or mortgage requires otherwise. So each individual property must have a separate bid and a separate sale. This is true even where the property consists of several lots or parcels, of course, unless the deed of trust or mortgage requires otherwise. The third component of SB 1079 is some new obligations on these trustees. They're required to maintain a website and a telephone number that gives 24/7 access free of charge with up-to-the-date information about the trustee sale, including the date of the sale and the amount of the last and highest bid. They must post this information within 48 hours of the trustee sale unless it's being sold to a prospective owner-occupant, and this information must be live for 45 days following the sale. Additionally, trustees are now required to include certain language in the notice of sale and post it on the front door of single-family residences. And this informs the tenants of their rights to purchase the property and telling them that they need not exceed the last bid, they just need to meet the one at the trustee sale. Right. The last component of the bill is an increase of fines for failure to maintain vacant properties acquired through foreclosure. So there was already a law in the books requiring purchasers to maintain homes purchased out of foreclosure. This bill has now increased the fine from $1,000 a day to $2,000 a day. The owners are given notice and an opportunity to remedy the situation. However, if that lingers, the city and county officials can have the discretion to levy that fine. If the violation lingers more than 30 days, the fine can increase to a maximum of $5,000 per day. And failure to maintain would include allowing foliage to overgrow, allowing squatters or trespassers to maintain and to be in the property, and to allow standing water to invite mosquitoes. Just some of the examples. So some of the predictions of SB 1079, it's only been on the books for about 5 weeks, so not sure we've seen it come into play too much yet. and it actually sunsets on January 1st, 2026. So we'll have some time to see it play out. So the goal is really to level the playing field between California corporations and tenant owner occupants and avoid a repeat of the 2007-2008 crisis. This actually was prompted in part by a coalition of unhoused mothers up in the Oakland area. They had taken issue with some vacant homes that were being unkempt and were virtually abandoned. They took possession of the property and stayed there for about 2 months until they were forcibly evicted. But this actually brought about big attention and sparked the interest of one of the state legislators to introduce this bill. There are a number of critics of the bill saying its language is ambiguous, which always invites litigation, and that the 45-day process of the right of first refusal may actually temper interest in foreclosure sales. They also say that the longer timelines will not necessarily translate to better outcomes for homeowners and tenants. Time is money, and losses incurred by the lenders may trickle down to the borrowers. Another opponent raised a point that said, where would we have bottomed out in 2008 if the corporations had not stepped in to purchase the homes? Lenders are not in the real estate business, and they needed someone to come in and help recoup their losses. Another concern is that when a tenant is in possession, if they file for bankruptcy, that right to purchase may become part of their bankruptcy estate and may further delay the process. So while some of the opponents think that the goal is laudable, they don't think that this is a good way to go about addressing affordable housing in California. And that's it. Any questions?
Well, yeah, I was thinking about the wrongful foreclosure litigation that happens all the time in California, because the foreclosure process is very technical, and you have to follow the process to a T. Otherwise, it can be voided out later by a court. And it's interesting with this new Senate bill that, it's relatively new, so there hasn't been really any litigation concerning it yet, but I could see how giving that notice to the tenant could be a potential hazard or pitfall for the foreclosing lender, making sure that that notice is accurate and it's served right, and you have some type of confirmation that the tenant actually received it. Because now you could potentially have wrongful foreclosure claims, not just from the borrower that's being foreclosed on, but also this tenant that may have a right to purchase the property. So I feel like that could be an area that if I was a foreclosure trustee, I would pay special attention to that and make sure that that notice is 100% accurate and served exactly how it says.
Yeah, and it's the language that's required is in the statute. So it's a copy paste situation. It's not something that they would want to paraphrase or skip hoops on or anything. So yeah, I think that's something that's going to be important. One of the main points of this bill is to get tenants into the housing market. And so by giving them the ability to just meet the highest bid at the trustee sale, there's definitely a favorable look to tenants. So I could see them, a court wanting to protect them with any kind of failures on the trustee part.
Yeah, and another thought too is that I think if you're in the business of real estate investing and you're always looking for distressed properties or properties that are being foreclosed on, and you're in the business of going to those foreclosure sales and making offers to purchase those properties, this now creates another level of diligence that you need to do. When you select a property that's being foreclosed on and you want to make a bid, you're going to want to, you normally do drive by the property anyways to look at it and see what the condition is, but now you want to know, is there a tenant in there? And if so, are they in a position to make an offer to purchase this property at the foreclosure sale? Because that's going to delay this foreclosure investor that's buying that property to invest and flip it. They're going to have to delay their timeline. And as you said in the one slide, time is money for all these people. So knowing in advance to plan ahead that you're going to have to delay for 45 days is good information to know.
Right. I think a few of the opponents said, the large corporations are still going to play the game, but some of the smaller ones might find it to be just too much of a hassle. You do a lot of due diligence on a number of properties, only for that to be kind of undone at the last minute by a tenant buyer who's able to meet the bid at the trustee sale.
Interesting. Well, it'll be interesting to see how this plays out in the future here, given that, the pandemic has created a lot of real estate defaults. The moratoriums are still in place on some level for foreclosures and for evictions. And once that opens up, it'll be interesting to see how quickly these foreclosures move and how this rule comes into effect.
Yeah, there's a lot of gray area in the language, so it'll be interesting to see how it kind of plays out. I agree. Any other questions, comments, concerns?
No, that was very informative. Thank you very much. So everyone, that was Daniel Ward presenting a webinar on the Senate Bill 1079, and we did record it. So if you didn't get to see the whole thing, or you want to share it with a friend or email it to somebody, just follow the instructions on the screen, I believe, and we'll get that information over to you. But thank you for your time. And Danielle, do you have anything to say?
Nope. Thanks so much for attending. If you have any questions, feel free to email any of us or reach out by phone. Thank you.
Thanks, everybody. Have a great day.